For the table of contents, this file. Part A, Notice and Execution of Award, Section 66. Part B, Period of Action, Performance Security, Section 67 to 68. Part C, Failure to enter into contract, Reservation Clause, Section 69 to 70. Part R, Errors on the approved budget for the contract, ABC. Part T, Notice to proceed and commencement of contract time. This is file 1 of a 5-file guide covering the full contract lifecycle under RA number 12009. File 2, Contract Implementation, Money, Time, and Changes, Parts D, V, S, Q, Y. File 3, Completion, Termination, and Warranty, Parts E, F, U, G, W, Z. File 4, Disputes, Protests, and Reconsideration, Parts H, I, J, 10. File 5, Prohibited Acts, Contract Terms, and Reference, Parts K, L, M, N, O, P. Next slide. Notice and Execution of Award. Legal Basis, IRR of RA number 12009, Section 66. Next slide. Definition. Notice and execution of award is the stage where the BAC's post-qualification finding is converted into an actual government commitment. It covers a formal recommendation to the head of the procuring entity, HOPE, the HOPE's approval or disapproval, and, if approved, the issuance of the Notice of Award, NOA, to the winning bidder, followed by contract signing. Next slide. The BAC's recommendation and supporting documents. This is based on IRR of RA number 12009, Section 66. 1. It states, the BAC shall recommend to the HOPE the award of contract to the bidder with the LCRB, MIRB, MARB, HRRB, SCRB, SIB, SARB or SRRB, as the case may be, after the post-qualification process has been completed. To facilitate the approval of the award, the BAC shall submit the following supporting documents to the HOPE. A. Resolution of the BAC recommending award. B. Abstract of bids. C. Duly approved program of work or delivery schedule and cost estimates. D. Document issued by the appropriate entity authorizing the procuring entity to incur obligations for a specified amount. And E. Other pertinent documents required by existing laws, rules, and regulations, or the procuring entity concerned. Within 3 calendar days from the issuance of the resolution recommending award of contract, the BAC shall notify all other bidders, in writing, of its recommendation. Please take note of this specific rule when reviewing procurement documents. Next slide. The HOPE's action and the Notice of Award. This is based on IRR of RA number 12009, Section 66. 2 and 66. 3. It states, within a period not exceeding 10 calendar days from the determination and declaration through a resolution by the BAC of the LCRB, MIRB, MARB, HRRB, SCRB, SEARB, SARB or SRRB, as the case may be, and the recommendation of the award, the HOPE or its duly authorized representative shall approve or disapprove the said recommendation. In case of approval, the HOPE or its duly authorized representative shall immediately issue the Notice of Award to the bidder. In the event that the approving authority shall disapprove the resolution on the award of the contract, such disapproval shall be based only on valid, reasonable, and justifiable grounds as enumerated under Section 70 to be expressed in writing. A copy of the decision disapproving the resolution shall be furnished to the BAC and the bidder. This is an important requirement to check during a compliance review. Next slide. Reconsideration of a disapproval, mechanism number 2. This is based on IRR of RA number 12009, Section 66. 4. It states, when applicable, the BAC shall conduct a post-qualification of the bidder with the next LCB, MEAB, or HRB, as provided in Section 63. 7 of this IRR. A request for reconsideration may be filed by the bidder with the HOPE within 3 calendar days from receipt of the notice of disapproval or the explanation for the inaction. The HOPE shall resolve with finality the request for reconsideration within 7 calendar days from the filing thereof and furnish the bidder a copy of the resolution immediately from its promulgation. In no case shall the request for reconsideration stay or delay the bidding process. However, the request for reconsideration must first be resolved before any award is made. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Conditions before the contract may be awarded. This is based on IRR of RA number 12,009, Section 66. 5. It states, within 10 calendar days from receipt by the winning bidder of the notice of award, the following conditions should be complied before the contract may be awarded. A. Submission of the following documents by the winning bidder. 1. Valid JVA, if applicable. 2. A valid PCAB license and registration for the type and cost of the procurement project to be bid for foreign bidders in infrastructure projects. When the treaty or international or executive agreement expressly allows submission of such license and registration as a precondition to the notice of award, or 3. The SEC Certificate of Registration of the Foreign Corporation, or the SEC Certificate of Registration of the Foreign Consulting Firm, or the authority or license from the appropriate government agency or professional regulatory body of the foreign professionals engaging in the practice of regulated professions and allied professions, where applicable. B. Posting of performance security by the winning bidder in accordance with Section 68 of this IRR, and C. Signing of the contract by the parties. This rule is often a point of focus when verifying compliance with the law. Next slide. Documents checklist, award stage. From the back to the HOPE, Section 66. 1. Resolution recommending award, abstract of bids, approved program of work, delivery schedule and cost estimates, budget authorization document, and other pertinent documents required by law. From the winning bidder to the procuring entity, within 10 days of NOAA receipt, Section 66. 5. Valid JVA, if applicable, valid PCAB license, foreign bidders, infrastructure, treaty-covered cases. SEC Certificate of Registration or Professional License, foreign professionals, where applicable, performance security, per Section 68, and the signed contract. Next slide. Step by step, from post-qualification to signed contract. 1. BAC completes post-qualification and passes the winning bidder. 2. BAC issues a resolution recommending award, with the 5 supporting documents, Section 66. 1. 3. BAC notifies all other bidders in writing within 3 calendar days of the resolution. 4. HOPE approves or disapproves within 10 calendar days of the BAC's resolution, Section 66. 2. 5. If approved, the notice of award is issued immediately, Section 66. 3. 6. If disapproved, must be on Section 70 grounds only, in writing, copy furnished to BAC and bidder. Bidder may file reconsideration mechanism number 2 within 3 days, Section 66. 4. 7. Winning bidder has 10 calendar days from NOAA receipt to submit documents, post-performance security, and sign the contract, Section 66. 5. Next slide. Period of action on procurement activities, performance security. Legal basis, IRR of RA number 12,009, Sections 67 to 68. Next slide. The 60/90th day ceiling. This is based on IRR of RA number 12,009, Section 67. 1 and 67. 2. It states, the procurement process, from the opening of bids up to the award of contract, shall not exceed 60 calendar days. All members of the BAC Secretariat, TWG. and other relevant procurement personnel shall be on a jury duty type of assignment until the notice of award is issued by the HOPE in order to complete the entire procurement process at the earliest possible time. The GPPB is authorized to adjust the period as may be deemed appropriate, provided that the adjusted period shall not exceed 90 calendar days. Keep this requirement in mind, as it directly affects the validity of the transaction. Next slide. Tolling, suspension of the period. This is based on IRR of RA number 12,009, section 67. 4. It states, the period of action on procurement activities is tolled or suspended, as follows. For early procurement activities, pending approval and effectivity of the GAA, corporate budget or appropriations ordinance, or the loan agreement in the case of FAPs, and B. During the suspension of the conduct of procurement activities, as determined by the BAC. The period of action on procurement activities which has been tolled or suspended shall begin to run again once the basis of such tolling or suspension no longer exists. The period of action on procurement activities shall not commence anew, but rather, grant the procuring entity the balance of the remaining period available. This is a key provision that procurement officers must apply correctly. Next slide. Purpose of performance security. This is based on IRR of RA number 12,009, section 68. 1. It states, to guarantee the faithful performance by the winning bidder of its obligations under the contract in accordance with the bidding documents. It shall post a performance security prior to the signing of the contract. The winning bidder is required to update the performance security posted prior to the issuance of a variation order or an amendment to order, if any. This detail is worth remembering when preparing supporting documents. Next slide. Performance security, form and amount, section 68. 4. Cash or cashiers, manager's check issued by a bank, LGU biddings. Other BSP certified banks allowed, goods and consulting services, 5%. Bank draft, guarantee, or irrevocable letter of credit issued by a bank. Foreign bank must be confirmed, authenticated by a local bank. Infrastructure projects, 10%. Surety bond callable upon demand, issued by a surety insurance company certified by the Insurance Commission, 30%. Next slide. Performance securing declaration, PSD. This is based on IRR of RA number 12,009, section 68. 2 and 68. 3. It states, sectors enumerated under Section 76 of this IRR may also be allowed to post a Performance Securing Declaration, PSD, in lieu of a performance security. The PSD shall state, among others, that the winning bidder shall be blacklisted from being qualified to participate in any government procurement activity for 1 year. In case of the first offence, or 2 years, if with a prior similar offence, in the event that it violates any of the conditions stated in the contract. An unnotarized PSD may be accepted, subject to submission of a notarized PSD before any payment is made by the procuring entity. This provision is frequently checked during document review. Next slide. Validity period and additional security, infrastructure. This is based on IRR of RA number 12,009, section 68. 6 and 68. 7. It states, the winning bidder shall ensure that the performance security remains effective until the issuance of the certificate of final acceptance. The performance security may be released by the procuring entity after the issuance of the certificate of final acceptance, provided that the procuring entity has no claims filed against the performance security. For the procurement of infrastructure projects, the winning bidder shall post an additional performance security following the schedule above to cover any cumulative increase of more than 10% over the original value of the contract as a result of amendments to order or change orders, extra work orders and supplemental agreements, as the case may be. The winning bidder shall cause the extension of the validity of the performance security to cover approved contract time extensions. Please take note of this specific rule when reviewing procurement documents. Next slide. Proportional reduction. This is based on IRR of RA number 12,009, section 68. 8. It states, the procuring entity shall allow a proportional reduction in the original performance security in the following cases. A. In case of a reduction in the contract value. Or B. In case of procurement of infrastructure projects, for partially completed works under the contract which are usable and accepted by the procuring entity, and the use of which will not affect the structural integrity of the entire project, provided that any reduction in the performance security is more than 10%, and that the aggregate of such reductions is not more than 50% of the performance security. This is an important requirement to check during a compliance review. Next slide. Why this matters. The 60/90th stay ceiling in section 67. 1 to 67. 2 is the outer boundary against which every earlier timeline in the bidding stage series, pre-procurement conference through post-qualification, must ultimately fit. If mandatory sub-timelines threaten to exceed 60, or GPPB adjusted 90, days, something needs tolling under section 67. 4. It cannot simply run over. Performance security is frequently confused with bid security, posted earlier, at bid submission, and with warranty security, posted later. Covering the post-completion defects liability period, see Part G. All three exist at different times, guarantee different things, and are governed by different sections. Next slide. Failure to enter into contract, reservation clause. Legal basis, IRR of RA number 12,009, sections 69 to 70. Next slide. Failure under alternative mode award criteria. This is based on IRR of RA number 12,009, section 69. 1. It states, if the bidder with the SCRB, SIB, SARB, or SRRB fails, refuses or is unable to 1. Submit the documents required under section 66. 5 of this IRR, 2. Enter into contract with the procuring entity, or 3. Post the required performance security within the period stipulated in this IRR or in the bidding documents. The bidder shall be disqualified from further participating in the bidding process. Further, the bid security shall be forfeited, and the appropriate sanctions provided in this IRR and existing laws shall be imposed, except where such failure, refusal or inability is through no fault of the said bidder. Consequently, a failure of bidding shall be declared, and the rebidding of the procurement project shall be undertaken, if appropriate. Government personnel should follow this provision closely to avoid procedural defects. Next slide. The Cascade Rule, LCRB, MEARB, MARB, HRRB. This is based on IRR of RA number 12,009, section 69. 2. It states, if the bidder with the LCRB, MEARB, MARB, or HRRB fails, refuses or is unable to 1. Submit the documents required under section 66. 5 of this IRR, 2. Enter into contract with the procuring entity, or 3. Post the required performance security within the period stipulated in this IRR or in the bidding documents. The bidder shall be disqualified from further participating in the bidding process. The BAC shall disqualify the said bidder and initiate and complete the post-qualification process on the bidder with the second LCB, MEAB, MAB, or HRB, provided, however, that in the case of consulting services, the second highest rated bid has successfully undergone the negotiation stage in accordance with section 62 of this IRR. This procedure shall be repeated until the LCRB, MEAB, MARB, or HRRB is determined for award. However, if no bidder passes post-qualification, the BAC shall declare the failure of bidding and conduct a re-bidding with republication, if appropriate. Should another failure of bidding occur after the conduct of the re-bidding, the procuring entity may enter into a negotiated procurement. This rule is often a point of focus when verifying compliance with the law. Next slide. The reservation clause, full text. This is based on IRR of RA number 12,009, section 70. It states, the HOPE reserves the right to reject any and all bids, declare a failure of bidding, or not award the contract in the following situations. A. If there is prima facie evidence of collusion between appropriate public officers or employees of the procuring entity, or between the BAC and any of the bidders. Or if the collusion is between or among the bidders themselves, or between a bidder and a third party, including any act which restricts, suppresses or nullifies, or tends to restrict, suppress or nullify competition, or influences or tends to influence the bidding process. B. If the BAC is found to have failed in complying with the applicable law or in following the prescribed bidding procedures, or C. For justifiable and reasonable grounds, where the award of contract will not redound to the benefit of the government in the following instances. 1. If the physical and economic conditions have significantly changed so as to render the project no longer economically, financially, or technically feasible, as determined by the HOPE. 2. If the project is no longer necessary, as determined by the HOPE, or 3. If the source of funds for the project has been withheld or reduced through no fault of the procuring entity. Keep this requirement in mind, as it directly affects the validity of the transaction. Next slide. Why this matters. Section 70 is the only valid basis a HOPE may cite to disapprove an award recommendation, referenced directly in Section 66. 3. A disapproval citing any ground outside this list of 3, collusion, BAC non-compliance, or changed circumstances, is itself legally vulnerable and a proper subject of reconsideration mechanism number 2, Section 66. 4. Next slide. Errors on the approved budget for the contract, ABC. What the ABC is, what happens when a bid exceeds it, and what happens when the ABC itself turns out to be wrong. Next slide. The full accurate definition. This is based on IRR of RA number 12,009, section 5, A. It states, approved budget for the contract, ABC, refers to the budget for the contract duly approved by the head of the procuring entity, HOPE, within the authorized amount in the General Appropriations Act, GAA, continuing and automatic appropriations, or other authorized source of funds. In the case of national government agencies, NGAs, the corporate operating budget approved by the governing boards, pursuant to Executive Order, EO, No. 518, S. 1979. In the case of GOCCs, GFIs, and RA No. 8292, or the Higher Education Modernization Act of 1997, in the case of SUCs. And the budget for the contract approved by the Sangunion through an appropriation ordinance in the case of LGUs. For multi-year contracts, for which a multi-year contractual authority, MYCA, or an equivalent document is required. The ABC shall be the total project cost reflected in the MYCA or equivalent document. For foreign-funded procurement, the ABC refers to the cost estimate prepared by the procuring entity and approved by the foreign government, or foreign or international financing institution as specified in the treaty or international or executive agreement. This is a key provision that procurement officers must apply correctly. Next slide. 5 distinct ABC sources, 1 term. NGAs, the GAA, continuing and automatic appropriations included, or another authorized source of funds, as approved by the HOPE. GOCCs and GFIs, the corporate operating budget, approved by the governing board under Executive Order No. 518, S. 1979. SUCs, the corporate operating budget under RA No. 8292, Higher Education Modernization Act of 1997. LGUs, the budget approved by the Sangunion through an appropriation ordinance. This is the source most directly relevant to municipal and provincial audit work. Multi-year contracts, the total project cost reflected in the multi-year contractual authority, MYCA, issued by the DBM, not a single fiscal year's allocation. Foreign-funded procurement. The cost estimate prepared by the procuring entity and approved by the foreign government or financing institution per the governing treaty or agreement. A source distinct from all of the above. Next slide. Bids in excess of the ABC. Procurement officers and auditors should refer to the applicable Government Procurement Policy Board issuances and the standard bidding documents for the specific procedures on this topic. Next slide. When the ABC itself is wrong, adjustment requires rebidding. Procurement officers and auditors should refer to the applicable Government Procurement Policy Board issuances and the standard bidding documents for the specific procedures on this topic. Next slide. Arithmetical errors in a bid are not the same as ABC errors. This is based on GPPB Non-Policy Matter, NPM, No. 010-2006. It states, as can be readily seen from the expressed provision of Section 32. 4. One of the implementing rules and regulations Part A, IRA, of Republic Act No. 9184, R. A. 9184, the BAC can make corrections on arithmetical errors in the financial proposals of the bidders during the detailed evaluation of bids. It is clearly within the ambit of the BAC's authority to make the necessary corrections on the bidder's financial proposals, since the corrected computations by the BAC shall be the basis for the determination of the lowest calculated bid. This detail is worth remembering when preparing supporting documents. Next slide. The practical distinction this draws. A bidder's own arithmetical error in its financial proposal, e.g., a multiplication mistake in extending a unit price, is correctable by the BAC during bid evaluation, and the corrected figure becomes the basis for ranking. This is routine and does not require rebidding. An error in the ABC itself, the procuring entity's own budget figure, not a bidder's submission, is a different category of defect entirely, and GPPB Resolution Number 07-2005 requires rebidding with re-advertisement once the ABC is adjusted, Part R. 3. Not a simple correction. A related GPPB clarification, NPM number 008-2014, confirms this same non-discretionary logic applies even to a bidder's own erroneous supporting computation, the net financial contracting capacity, or NFCC. If the submitted NFCC computation is at least equal to the ABC, it passes on a pass-fail basis. Regardless of the fact that the computation was based on an erroneous data or a mistake in arithmetical computation. The BAC does not go behind the numbers to award credit for a correct computation that would have failed. Next slide. Audit observations, errors on the ABC. 1. ABC computed without a supporting detailed engineering cost estimate, program of work, or current market price canvas, leaving no verifiable basis for the figure used. 2. ABC for an LGU project cited to the wrong appropriation ordinance, or approved by an official without delegated authority from the Sangunion. 3. A defective ABC adjusted mid-bidding without the required rebidding and re-advertisement under GPPB Resolution Number 07-2005, the process simply continued with the corrected figure. 4. Bids that in fact exceeded the ABC accepted for further evaluation instead of being automatically rejected at bid opening. 5. A bidder's own arithmetical error in its financial proposal treated as grounds for outright disqualification, rather than corrected by the BAC as Section 32. 4. One equivalent authority allows. 6. Multi-year contract ABC computed from a single year's budget allocation instead of the total project cost reflected in the MYCA. 7. Foreign-funded project ABC cited to a domestic appropriations document instead of the cost estimate approved under the governing treaty or financing agreement. Next slide. Notice to proceed and commencement of contract time. The baseline date, every slippage, liquidated damages, and warranty period computation in this reference ultimately runs from next slide. Why the NTP date is not a formality. The Notice to Proceed, NTP, is the document by which the procuring entity formally directs the winning bidder to begin performance. And it is the reference point from which contract time, and therefore every downstream computation of negative slippage, Part Q, liquidated damages, Part D. 1, and the warranty period, Part G, is measured. A late-issued NTP, or an NTP issued before the Section 66. 5 preconditions, documents, performance security, signed contract, were actually complete. Creates a contract time baseline that does not match the contract's actual legal starting point, which in turn misstates every slippage percentage computed afterward. This is precisely why the award stage documents checklist in Part A. 6 places the Notice to Proceed as a document distinct from, and issued after, the Notice of Award and the signed contract. It is not interchangeable with either. Next slide. Its place in the sequence already established in this reference. This is based on IRR of RA number 12009, Section 66. 5, see Part A. 5. It states, Section 66. 5 requires, within 10 calendar days from the winning bidder's receipt of the Notice of Award, submission of the required documents, posting of the performance security, and signing of the contract. The Notice to Proceed is issued after this sequence is complete. It is the document that actually starts the contractor's performance obligations and the running of contract time. Distinct from the Notice of Award, which announces the winner, and the signed contract, which fixes the parties' obligations on paper. This provision is frequently checked during document review. Next slide. An important note on the specific timing rule. Procurement officers and auditors should refer to the applicable Government Procurement Policy Board issuances and the standard bidding documents for the specific procedures on this topic. Next slide. Audit observations, Notice to Proceed. 1. NTP dated before the performance security was actually posted or before the contract was actually signed, contrary to the Section 66. 5 sequence. 2. NTP not found on file at all, with contract time instead measured informally from the date of the signed contract or the Notice of Award. Producing an incorrect baseline for every slippage and liquidated damages computation. 3. A significant, undocumented gap between contract signing and NTP issuance, with no explanation on file for the delay and no corresponding adjustment considered for the contractor's mobilization timeline. 4. NTP issued for the full contract scope despite an unresolved right-of-way or site possession issue, effectively starting the compensable contract time clock before the contractor could actually mobilize on the ground. Next slide. Deadlines, delays, and technicalities. Every date in Parts A, B, C, R, and T is a legal trigger, not a scheduling suggestion. Missing one changes what happens next. Next slide. Delayed issuance of the Notice of Award. Section 66. 2 gives the hope a period not exceeding 10 calendar days from the BAC's resolution to approve or disapprove the award recommendation. The text sets no exception for a longer period. Every additional day beyond that window, with no documented justification on file, is itself a compliance gap, regardless of whether the eventual decision was correct. Treat an undated or unexplained delay in the Notice of Award as a finding on its own, separate from whatever the award decision itself turns out to be. Next slide. Delayed compliance with the Section 66. 5 preconditions. The winning bidder has 10 calendar days from receipt of the Notice of Award to submit documents, post performance security, and sign the contract, Section 66. 5. This is the bidder's clock, not the procuring entity's, but the audit risk runs both ways. A procuring entity that quietly extends this window without documented justification, or that allows a contract to be signed after the window closed without invoking the proper disqualification, re-ranking procedure, Section 69, has created a technical defect in the award itself. Next slide. Delayed or undocumented issuance of the Notice to Proceed. 12,009 Iranian rials subsection fixing the exact number of days for NTP issuance after contract signing. That does not make the date unimportant, it makes it more important to document, because there is no fallback statutory cushion to rely on if the date is contested. Any unexplained gap between contract signing and NTP issuance should be treated as a red flag requiring its own written justification on file, since it directly determines the baseline for every negative slippage and liquidated damages computation that follows. Next slide. Missed 3-day bidder notification and 3-day reconsideration windows. Two short, easily missed windows sit inside Part A, the BAC's 3 calendar days to notify all other bidders of its award recommendation, Section 66. 1. Under disappointed bidders 3 calendar days to file reconsideration mechanism number 2 against a hope disapproval, Section 66. 4. Both a calendar day, not working day, deadlines. A notification sent, or a reconsideration filed, even one calendar day late is technically defective regardless of good faith intent. Next slide. ABC adjustment without the required re-bidding. The moment an ABC is adjusted, GPPB resolution number 07-2005 requires re-bidding with re-advertisement, not a quiet continuation of the same bidding process with a corrected figure. A procuring entity that adjusts an ABC mid-process and simply proceeds has created a technical defect in the entire award that follows, no matter how reasonable the adjustment itself was. Next slide. Misconceptions. 10 commonly held but legally inaccurate beliefs about award, eligibility, and commencement, corrected against the accurate IRR. Next slide. On the HOPE's approval window. A common misconception is this: a HOPE can take as long as reasonably needed to approve or disapprove an award recommendation, as long as it eventually happens. The correct rule is as follows, Section 66. 2 fixes this at a period not exceeding 10 calendar days from the BAC's resolution. No open-ended reasonableness standard is stated in the text. Next slide. On reconsideration mechanism number 2 and the bidding process. A common misconception is this: filing a request for reconsideration against a HOPE disapproval of award pauses or stays the bidding process until it is resolved. The correct rule is as follows, Section 66. 4 explicitly states the opposite: in no case shall the request for reconsideration stay or delay the bidding process. What it does block is the actual award, which cannot be made until the reconsideration is first resolved. Next slide. On the reservation clause. A common misconception is this: the reservation clause lets a HOPE reject any bid or declare a failure of bidding for essentially any reason it considers sufficient. The correct rule is as follows. Section 70 limits this to exactly 3 enumerated grounds: prima facie collusion, back non-compliance with law or procedure, or specific justifiable, reasonable grounds where award would not benefit government. A disapproval outside these 3 grounds is itself defective. Next slide. On the ABC being a single, uniform figure type. A common misconception is this: the ABC is computed and approved the same way regardless of what kind of procuring entity is involved. The correct rule is as follows. Section 5 sets out 5 distinct sources: the GAA for NGAs, the corporate operating budget for GOCCs, GFIs, RA number 8,292 budgets for SUCs, Sangunian appropriation ordinances for LGUs, and foreign government, financing institution cost estimates for foreign-funded procurement. Each governed differently. Next slide. On bids exactly equal to the ABC. A common misconception is this: a bid priced exactly at the ABC is treated the same as a bid that exceeds it, both get automatically rejected. The correct rule is as follows. The automatic rejection rule applies specifically to bids received in excess of the ABC. A bid priced at or below the ABC is not automatically rejected on that basis. Next slide. On arithmetical errors in a bid. A common misconception is this: any arithmetical error found in a bidder's financial proposal disqualifies that bidder outright. The correct rule is as follows. GPPB non-policy matter number 010-2006 confirms the BAC has authority to correct arithmetical errors during detailed bid evaluation, and the corrected figure becomes the basis for ranking. This is routine correction, not automatic disqualification. Next slide. On the notice to proceed and the notice of award. A common misconception is this. The notice to proceed and the notice of award are essentially the same document issued at different points. The correct rule is as follows. They are distinct instruments with different legal functions. The notice of award announces the winning bidder, Section 66. 3. The notice to proceed, issued only after the Section 66. 5. Preconditions are satisfied, is what actually starts the contractor's performance obligations and the running of contract time. Next slide. On when performance security must be posted. A common misconception is this. Performance security can be posted any time before the project is completed, as long as it's on file eventually. The correct rule is as follows. Section 68. 1 requires it prior to the signing of the contract. It is one of the 3 express preconditions, alongside documents and contract signing, that must be satisfied within the winning bidder's 10-day window under Section 66. 5. Next slide. On a single failed post-qualification ending the bidding. A common misconception is this. If the top-ranked bidder fails post-qualification, the entire bidding must immediately be declared a failure. The correct rule is as follows. Section 69. 2 requires the BAC to first disqualify that bidder and proceed to post-qualify the second-ranked bidder, repeating the cascade until a bidder passes or all bidders are exhausted. Only then is a failure of bidding declared. Next slide. On which disqualification ground applies to alternative mode awards. A common misconception is this. The same cascade to next bidder rule that applies to competitive bidding awards, LCRB, MEARB, MARB, HRRB, also applies automatically to single, alternative mode awards, SCRB, SEARB, SARB, SRRB. The correct rule is as follows. Section 69. 1 treats single mode award failures differently. The bidder is simply disqualified, its bid security forfeited, and the failure of bidding is declared directly. There is no next ranked bidder to cascade to, because a single mode award by definition has no ranked competitors. Next slide. Audit observations. 20 recurring compliance gaps in award, performance security, the reservation clause, the ABC, and the notice to proceed. Next slide. Award and performance security. 1. Notice of award issued beyond the 10 calendar day hope window, Section 66. 2. Without documented justification on file. 2. BAC's 3 calendar day notification to other bidders of its award recommendation not evidenced in the file, Section 66. 1. 3. 1 or more of the Section 66. 5 preconditions, documents, performance security, signed contract, not completed within the winning bidder's 10-day window, with no documented basis for any extension. 4. Disapproval of an award recommendation citing grounds outside the 3 enumerated in Section 70. 5. Reconsideration mechanism number 2 filed beyond the 3 calendar day window still entertained and acted upon by the Hope. 6. Hope's 7 calendar day resolution of a reconsideration mechanism number 2 request exceeded without documented reason. 7. Performance security amount below the required percentage for its form and project type, 5% goods, CS cash equivalent, 10% infrastructure bank instrument, 30% surety bond. Next slide. Performance security, failure to contract, and the reservation clause. 8. Additional performance security not obtained to cover a cumulative variation order increase exceeding 10% of the original contract value, Section 68. 7. 9. Performance securing declaration accepted without the required blacklisting consequence disclosure statement, Section 68. 2 to 68. 3. 10. The 60/90th calendar day procurement ceiling, Section 67. 1 to 67. 2. Exceeded without a documented tolling basis under Section 67. 4. 11. Failure of bidding declared for an LCRB, MEARB, MARB, HRRB award without first attempting the cascade to the next ranked bidder, Section 69. 2. 12. Bid security not forfeited despite an unjustified bidder failure to sign the contract or post-performance security, Section 69. 1. 13. A single, alternative mode bidder's failure treated as triggering the cascade rule instead of the direct disqualification and failure of bidding rule that actually applies to it, Section 69. 1. 14. Disqualification and bid security forfeiture imposed on a bidder despite the failure being through no fault of the bidder, the express exception in Section 69. 1. Next slide. The ABC and the notice to proceed. 15. ABC computed without a supporting detailed engineering cost estimate, program of work, or current market price canvas. 16. A defective ABC adjusted mid-bidding without the required re-bidding and re-advertisement under GPPB Resolution Number 07-2005. 17. A bid that in fact exceeded the ABC accepted for further evaluation instead of being automatically rejected at bid opening. 18. Multi-year contract ABC computed from a single year's budget allocation instead of the total project cost reflected in the MYCA. 19. NTP dated before the performance security was posted or before the contract was signed, contrary to the Section 66. 5. Sequence. 20. No NTP on file at all, with contract time instead measured informally from the contract signing date or the notice of award. Producing an incorrect baseline for every downstream slippage and liquidated damages computation. Next slide. End of award, eligibility, and commencement. Every quotation in this file is drawn directly from the text of the implementing rules and regulations of Republic Act No. 12,009, or from the specific GPPB, DPWH, COA source cited on its slide, cross-checked section by section. Contract implementation, money, time, and changes, completion, termination, and warranty, disputes, protests, and reconsideration, and prohibited acts, contract terms. And reference continue. This references coverage of the remaining stages of the contract lifecycle. This concludes this audio guide. Thank you for listening. Table of contents.